truth in court proceedings is not merely a legal expectation, it is a constitutional imperative. The courtroom is where justice is rendered, where the accused stand trial, and where verdicts carry consequences that may affect liberty, reputation, and life itself. In this hallowed space, every act of the judge, the prosecutor, the defense attorney, and perhaps most consequentially, the testifying law enforcement officer is bound by a sacred duty to speak with complete candor. Among all the participants in a trial, officers often carry the greatest evidentiary weight. Their testimony is presumed credible, their reports taken as fact, and their presence seen as authoritative. Because of this, any deviation from truthfulness by a law enforcement officer does not simply distort an isolated moment in the trial, it contaminates the very process by which truth is determined and justice is served. This chapter explores how truth operates and sometimes fails in court proceedings. It addresses the unique power of officer testimony, the judiciary's reliance on officer candor, and the consequences of false or misleading courtroom statements. It also examines how systemic pressures and insufficient oversight erode this critical function and what reforms are necessary to restore integrity. Officer testimony and its impact. The weight of the uniform. When a police officer takes the stand, jurors see more than an individual, they see an institution. Officers are trained to project confidence, professionalism, and command presence. These characteristics, cultivated on the street, carry over into the courtroom, where demeanor and delivery often influence how testimony is received. In many cases, officers are perceived as neutral experts, narrating a factual series of events without bias. This perception, however, is not always deserved. Officers, like all human beings, are susceptible to bias, memory errors, and personal motivations. But unlike lay witnesses, their words carry the authority of the state. This amplifies the harm when those words are false, misleading, or strategically incomplete. If an officer fabricates a confession, distorts a suspect's behavior, or omits exculpatory facts, they are not merely lying, they are weaponizing the power of the state to secure a conviction. Corroboration through conduct. Officer testimony also has the unique ability to corroborate itself through official documentation. Reports, video evidence, forensic logs, and physical evidence are all filtered through the lens of police conduct. When officers testify in court, they can effectively align all evidence with their narrative, even when that narrative is incomplete or inaccurate. This phenomenon gives officers the ability to construct a paper reality that is difficult for defense attorneys to unravel. If discrepancies exist, they are often dismissed as procedural errors rather than evidence of intentional deceit. Courts must be especially vigilant in recognizing that consistency between testimony and documentation does not always equate to truth, particularly when all sources originate from the same institutional hand. Judicial reliance on officer truthfulness. Suppression hearings and probable cause. Many of the most critical legal determinations in criminal trials occur before the jury is ever seated. Suppression hearings, where judges evaluate the constitutionality of searches, seizures, or confessions, are often decided based entirely on officer testimony. In these contexts, the judge acts as the trier of fact, and the officer is often the sole witness. Here, the stakes are high. If an officer claims that a suspect voluntarily consented to a search, or that probable cause existed for an arrest, the court must weigh that testimony carefully. Yet, because such claims are rarely corroborated by independent witnesses, the judge often has little choice but to credit the officer's word, especially if there is no contrary evidence. This dynamic places immense power in the hands of officers and makes judicial proceedings vulnerable to manipulation by dishonest testimony. Qualified immunity and judicial deference. In civil litigation against law enforcement, particularly in cases alleging constitutional violations, courts apply the doctrine of qualified immunity. This legal principle protects government officials from liability unless they violated clearly established rights. In determining whether an officer's conduct was reasonable, courts often rely on the officer's own account of the incident. This reliance creates a troubling feedback loop. Officers' narratives shape the judicial record, which in turn justifies their actions retroactively. When these narratives are untrue or misleading, courts may unknowingly endorse unconstitutional behavior, further insulating misconduct from accountability. Judicial deference to officer testimony is particularly problematic when it substitutes for independent factual analysis. Consequences of false or misleading testimony. Perjury and the rarity of prosecution. Perjury, knowingly making false statements under oath, is a crime. But despite the gravity of the offense, prosecutions for officer perjury remain exceedingly rare. Even when judges or prosecutors suspect dishonesty, the institutional reluctance to bring charges against fellow members of the legal system often results in silence or administrative discipline rather than criminal consequences. This tolerance of officer dishonesty sends a damaging message that the rules do not apply equally, and that truth in court is negotiable depending on the source. Officers who commit perjury often remain on the force, testifying in future cases, their credibility impaired but unchallenged. Such systemic leniency degrades the trial process and incentivizes further misconduct. The domino effect, tainted cases. False testimony does not remain confined to a single case. Officers whose integrity is compromised may have been involved in dozens or hundreds of other prosecutions. When their dishonesty is exposed, a cascade of consequences follows. Past convictions may be overturned, ongoing cases dismissed, and plea agreements vacated. This domino effect is both legally necessary and institutionally destabilizing. It forces prosecutors to re-examine closed files, victims to relive traumatic events, and courts to reconcile the unsettling reality that justice was rendered on false premises. The cost in human terms and institutional credibility is immense. Wrongful convictions. Among the most tragic outcomes of officer dishonesty in court are wrongful convictions. National studies of exoneration cases consistently identify police misconduct, including false testimony, as a leading cause. Innocent people have lost decades of their lives because an officer lied about a confession, planted evidence, or concealed exculpatory information. These miscarriages of justice are not mere accidents, they are preventable failures. They occur in environments where officers are not adequately trained on their ethical duties, where prosecutors do not challenge suspicious narratives, and where courts defer too easily to official accounts. The human cost of these failures is incalculable. Systemic factors that enable dishonesty, courtroom culture, and adversarial blindness. The adversarial nature of court proceedings creates a psychological environment where the pursuit of victory can overshadow the pursuit of truth. Prosecutors may become overly aligned with police witnesses, seeing them as allies rather than potential sources of error. Defense attorneys, burdened by high caseloads and limited access to discovery, may struggle to expose inconsistencies or lies. In this environment, courtroom culture becomes one of performance rather than truth-finding. Officers are coached on how to testify, rehearsed on what to say, and shielded from aggressive cross-examination by prosecutorial objections. Juries are often unaware of an officer's disciplinary history or credibility issues, particularly in jurisdictions where Brady and Giglio obligations are poorly enforced. This adversarial blindness allows dishonest testimony to flourish unchecked. Prosecutorial complicity. While most prosecutors act in good faith, there are instances where prosecutorial misconduct enables or even encourages dishonest testimony. This may take the form of coaching witnesses to avoid damaging admissions, discouraging full disclosure, or failing to act when confronted with inconsistencies. In some jurisdictions, prosecutors continue to call officers as witnesses despite knowing of past misconduct. This practice, known as using dirty cops, reflects a troubling compromise of ethical duties in favor of expedient convictions. It also poses significant risk. Once the officer's credibility is exposed, every case in which they testified becomes suspect. Prosecutors have an affirmative duty to disclose material that impeaches their own witnesses. When they fail to do so, they violate both constitutional law and their professional responsibilities. Still, many prosecutors operate without sufficient mechanisms to track officer credibility, relying on informal practices or incomplete databases that fail to catch red flags in time. Judicial passivity. Judges are the final arbiters of truth in the courtroom, yet they are often hesitant to confront officers over dishonest or misleading testimony. Whether out of deference, lack of evidence, or institutional inertia, many judges fail to make credibility findings even when confronted with suspicious statements. This passivity reinforces a dangerous dynamic. Officers are rarely challenged on the stand, rarely sanctioned for perjury, and rarely excluded from future testimony. In some cases, judges will simply note concerns about an officer's credibility in rulings without taking further action, allowing the officer to continue testifying in other courts. Reform and restoration of integrity. Strengthening Giglio and Brady compliance. Improving truth in court begins with enforcing existing disclosure rules. Prosecutors must develop systematic approaches to identify, track, and disclose officer credibility issues. Giglio databases, sometimes called do not call lists, should be formalized, transparent, and updated regularly. Defense attorneys must be given timely access to these disclosures so that they can prepare effective cross-examinations. Police departments must also recognize their role. They must proactively inform prosecutors of sustained misconduct, perjury findings, or other credibility concerns. Officers with damaged credibility must be removed from courtroom roles or reassigned altogether. Maintaining a testifying officer with known issues compromises every case they touch. Independent oversight of testimony. Court testimony should not be immune from accountability. Civilian review boards, inspector generals, or independent ethics panels should be empowered to investigate allegations of false testimony, especially when raised by defense attorneys or judges. Findings should be shared with licensing boards and made available to prosecutors. Such oversight introduces a necessary check into a system where historically only the most egregious examples of dishonesty have triggered consequences. With independent scrutiny, patterns of misconduct can be detected early and addressed before innocent people are harmed. Judicial training and action. Judges must be trained to recognize the signs of misleading testimony and empowered to take corrective action. This includes making explicit findings of untruthfulness, referring officers for perjury review, and excluding unreliable witnesses from future proceedings. Courts must also allow greater transparency. Defense attorneys should be permitted to introduce credibility evidence, and juries should be informed when an officer has a documented history of dishonesty. Shielding jurors from this information does not protect the system, it undermines it. Conclusion. The courtroom is the final arena in the criminal justice process, the place where facts are tested, narratives are scrutinized, and decisions of guilt or innocence are made. When truth is absent from this space, the entire legal edifice becomes hollow. A fair trial cannot occur without honest testimony, and honest testimony cannot exist in a system that tolerates deceit, enables silence, and privileges institutional loyalty over constitutional integrity. For law enforcement officers, the obligation to tell the truth in court is not optional. It is a duty that flows from their oath, their badge, and their public trust. For prosecutors and judges, the obligation is to enforce that truth with vigilance, not complacency. And for the system as a whole, the challenge is clear. Truth must be defended not merely as a value, but as a structure reinforced at every level, protected by every safeguard, and restored where it has been lost. I am a dedicated author and researcher specializing in the intricate nexus of technology, law, and government. My extensive body of work includes a diverse array of books, scholarly articles, and policy papers that delve into the evolving challenges and opportunities presented by technological advancements within legal and governmental contexts. Through rigorous analysis and insightful exploration, I examine how emerging technologies such as artificial intelligence, cybersecurity, data privacy, and blockchain shape and are shaped by legislative frameworks, regulatory practices, and public policy initiatives. My publications aim to bridge the gap between technical innovation and legal governance, providing comprehensive resources for policymakers, legal professionals, technologists, and academics alike. By addressing critical issues like digital rights, cyber law, technology-driven governance, and the ethical implications of technological integration, my work contributes to the development of informed and adaptive legal systems capable of responding to rapid technological change. I am committed to fostering a deeper understanding of how technology influences governmental operations and legal standards, and vice versa, thereby promoting the creation of robust, equitable, and forward-thinking policies. In addition to my writing, I actively engage with government agencies, legal institutions, and technology firms to offer expertise and collaborate on initiatives that ensure the responsible and effective implementation of technology in public spheres. My dedication to exploring and elucidating the intersections of technology, law, and government underscores my commitment to advancing knowledge and facilitating informed decision-making in an increasingly digitalized world.